Amid the white paper on immigration, which is set to see the overhaul of migration laws in South Africa, the critical issue regarding the rights of asylum seekers in the Republic of South Africa to apply for asylum status is back in the Gauteng High Court in Johannesburg this morning. Let's now take you live to those court proceedings.
8.3.
Let me just take you on your statement that you want to tackle those outcomes on the basis of the legality principle. That's centrally a review, isn't it?
That's right.
To say the decisions did not comply or conform with the legality principle.
Yes.
How do we, as a court, review those decisions without, let's say, the record of the proceedings that gave rise to the decisions you want reviewed? Unless you are suggesting that the annexures are the record.
My Lord, based on what has been presented to us,
Yes.
we were told that this is the record of the interviews. Even when you look at the notice itself, there is a part where they make interview, and there is a part where they make outcome. So in our view, it was that this is a complete record of what has transpired. Thus, it was important that we must just bring illegality without a further record. And that was one of the reasons which we invited the respondents, so that if they wish to oppose or there is a record of some sort which they want to introduce, to present that in court.
So you're saying those annexures are the complete record?
We submit that they serve
You
as a
submit?
Yes, Lord.
Okay.
We submit that they serve as a complete record on what has been presented to us.
Okay.
Because at this stage, we don't have any information that suggests that there is another record that is still with the respondent for a reason that we don't know.
Yes.
So at this stage, we are confined based on what we have at the moment.
Yeah.
And we submit that looking at what is before us, in order to declare these regulations, the interviews, for lack of compliance, that order would be appropriate. And to deal with the issue of prejudice, because it is important that I deal with the prejudice that the applicants are going to suffer in the event this supplementary affidavit is not admitted, and to deal with the prejudice that the respondents are going to suffer in the event the submission of the affidavit is admitted without them filing an affidavit. Under prayer number 2, in fact, under prayer number 1, in the old notice of motion and in the amended notice of motion, we are asking that the applicants should remain in the Republic up until their applications are finalized. In terms of, I think it was number 3 or number 4 of the previous, of the old notice of motion, where we asked that the applicants must be given an opportunity to apply for an asylum and to be issued with a temporal permit pending the finalization of that application. Then we look at these interviews notices. The recommendation that has been made, it says the applicants are not recommended to apply for an asylum. Meaning, under paragraph 1 of our notice of motion, they cannot stay in the country. They cannot apply for an asylum permit as provided in the Act. Then, of importance, we must look at what is provided under Section 4 of the Refugees Act, the grounds for disqualification for one to apply for an asylum. This interview on good cause, it's not listed as one of the grounds in which one can be disqualified. In fact, at this stage, it's important that I must mention, as much as there is a different interpretation on when a good cause should be made, whether it's an overall process of making an application for an asylum. That's why in our amended notice of motion, we are not saying because they've been interviewed, that interview must not be conducted again. In order to deal with the prejudice that the respondents might suffer, if any, which I will submit that if they will still be having an opportunity to conduct an interview, there is no prejudice that is going to be suffered. That's why we have provided 2.3 of our amended notice of motion to say they must attend that interview. That interview must comply with Section 21, Subsection 1B, and Regulation 8.3 in order to make sure that there is compliance. So I will submit that at this stage the applicants are going to suffer prejudice because they are not going to be allowed to make an application for an asylum. In fact, what is going to happen, they will be deported. They will be taken to countries where, based on the papers that are before court, they have alleged or submitted rather that they have left those countries because of persecution. And this,
sorry, Mr. Gobi, we don't want you to argue the merits of the matter now. What we need to hear you on is why this amendment at this belated stage of the proceedings, how does it affect the respondents who have indicated that they wish to oppose and they would want to be given an opportunity to file answering papers to this new case that you're now attempting to bring before the court, and why can this not be dealt with at a later stage? Because there are other applicants who still have their main application before the court where there has not been a decision taken as far as their application for asylum seeking, and they want the relief that they have in Part A of the main application that's before court. That's actually what's been enrolled in. So that's really what we want to hear you on, because we want to hear the other side also. They've made a clear indication they wish to oppose it, and we want to canvass their views on that also, and then we'll rule on it, because we don't want to stop you from presenting an argument, but not on the merits.
Thank you, Madam.
Just on the lateness of the substantive application.
In fact, let me try to be short, answer your questions. First, the reason this application has been brought at a later stage, that's why initially I referred to the stamp that appears on the first page of the notice. That's the date in which the interview was conducted. And if the court can scroll down on the same document to go to, it will be, if the court may bear with me while I'm trying to find the page, it will be 12.41-3. That's the date that shows it's the same stamp. It was on the 23rd.
23rd November 2023.
23rd November. And the date in which these records were submitted to the applicant's attorneys, it was on Friday. The date on Friday was
the 24th.
It was the 24th. That's when he was given the records. The application was prepared over the weekend. Then on Monday, it was filed. The respondents were given an opportunity to file the answering affidavit. In fact, the notice of intention to oppose and the answering affidavit. Entered the intention to oppose, but they did not file an answering affidavit. We submit that, looking at the time in which we got the records, there is no way that this information could have been put in the initial founding affidavit. That's why it has been brought to court at this later stage. And the reason we are asking for a declaration, it's because the applicants are not going to be given an opportunity to apply for an asylum based on what has been said. And looking at the matter that is before court, these outcomes, they have an effect, because if this court, for example, agrees with the proposition that we make in the amendment to say the applicants should not remain in detention, they must be released, they must be afforded an opportunity to apply. That cannot happen because already, on good cause, they've been kicked out. And this is the reason, despite being aggrieved about the decision, we still submit that because of the failure to comply with the correct form and the manner in which that interview has to be conducted.
I think the question by Judge Collis essentially is, all that you've said about what's happened subsequently to papers being filed is, why is this aspect of the case being added to this case? Why is it not being brought separately? Because it seeks to attack outcomes that happened after the application was launched. I think that's the essence of why we want to. Why is it here? Why is it not brought separately? Because you want separate relief based on the outcomes that came out of the interviews, isn't it?
Malot, I'm not going to say we want a separate relief. But
you want those decisions set aside.
Yes, Malot. So that the matter that already is before court, when you make your decision in that matter, it does not affect the rights of the applicants. That's the reason we could not bring a separate application, and in consideration of that, because the applicants are in detention as we speak. So there is no way that we could have let the applicants continue languishing in jail, bringing a separate application, a review application that could take 6 months, even more than that.
Well, that matter there being heard in the High Court is with regards to an application that has been brought by 6 applicants testing the legal authority of Home Affairs as well as the Minister and officials to detain undocumented foreigners who have an intention to apply for asylum. That court case is continuing.